Hi guys, welcome to another initiative of News in 30 minutes. Now, thank you so much for all the support for the break that we will be taking from 25th to 5th. That is 25th of December to 5th of January. We will be taking a break, but that doesn't mean that you take a break from your studies. Always make sure that you shouldn't leave a gap in your preparation. Now, that doesn't mean shouldn't you try to relax. Yes, you have to relax. Yes, you have to give some time to yourself. Yes, you have to give time to some hobbies that you pursue, and yes, you have to give some time to your family. All this is very important for your mental health. Okay, and if you want to keep your mental health healthy, obviously you have to take that gap of relaxation, giving time to yourself, working on your hobbies, and giving time to your family. Okay, but this gap should not have or should not be in the count of days. You should not take 5 to 10 days break to do this. Okay, it should be very smartly interspersed. Okay, it should be very smartly dispersed within your preparation. Try to inculcate all these things within your preparation. That is, if you are studying every day for 10 hours, make sure that you spend 2 hours on all these things. Okay, in that way 2 hours you spend on this, 10 hours you can study. So in that way, whatever 10 hours that you study every day will be more effective, you will be more focused, and also you will not feel exhausted. Okay, that is the trick. The trick is not to wait until you take a break, but the trick is taking very small breaks that are interspersed in your preparation in such a way that you will not feel like you are preparing constantly. So this in a way will make you consistent but not make you exhausted. So that is the trick. All right. So give yourself a time, but make sure that you give your time regularly in a very small interval so that your preparation should not be hampered. If you take several days together as a break, then it becomes a problem for you to come back and regain that momentum. So this is not advisable. Okay, so with that, let us start off with today's news in 30 minutes and look at some of the important issues on the 21st of December 2023. Okay, the first important issue is the Parliament proceedings. Lok Sabha passes bill to replace British era criminal laws. Okay, they have amended the British era criminal laws. They have amended this for the second time. So three important laws that they have amended are: one, they have replaced, not amended, they have replaced, not amended, they have replaced Indian Penal Code 1860. They have replaced Criminal Procedure Code or 1973. Okay, and they have replaced Indian Evidence Act of 1872. Okay, so these both are colonial, and this also is colonial that was amended later on. However, all these three are now stand to be replaced. As I read it out, new laws are designed for the next 100 years, will remove colonial imprint, says our Home Minister. Terrorism is included as a separate category. Sedition is dropped. Mob lynching is present to invite a death penalty. Okay, so the laws are in tune with the trends that is happening within the criminal ecosystem, which will definitely make an attempt to reduce the incidence of such criminal activities. So let us just understand the brief changes that have been brought about by this introduction of new criminal laws. Now, before I get into the the exactness of what are all the important provisions that are replaced or that are brought in, just to give you a background, you should know the names also. This is one is Bharatiya Nyaya Sanhita Bill. Okay, Bharatiya Nyaya Sanhita Bill. This will replace the Indian Penal Code 1860. The next is Bharatiya Sakshya Bill. This will replace the Indian Evidence Act of 1872. And the next is Bharatiya Nagarik Suraksha Sanhita Bill. Okay, the Bharatiya Nagarik Suraksha Sanhita Bill will replace the Code of Criminal Procedure. Okay, so broadly these are the three bills that are going to replace the old laws that dictated our criminal justice system. Okay, so I hope you got this. Okay, now let us first look at some of the important provisions of our IPC. That is, let us look at first BNSS. What are all the provisions, important provisions of BNSS? That is Bharatiya Nyaya Sanhita Bill. And then later on we look at Bharatiya Nagarik Suraksha Sanhita Bill. What are all the important provisions? Okay, so first when I talk about Bharatiya Nyaya Suraksha Bill, okay, Bharatiya Nyaya Sanhita Bill. Okay, let me just Bharatiya Nyaya Sanhita Bill, BNSS. Okay, if you look at that BNSS, some of the important provisions are the terrorist act. Okay, is defined. The terrorist act is defined as a separate offense. That is the first provision. The terrorist act is defined as a separate offense. Okay, basically they say that it includes attack on India's integrity. It includes attack on India's integrity, on India's sovereignty, okay, on India's security, and India's not only security, it also involves attack on India's economic security as well, and also it involves trying to spread terror among people. So all these are included as terror activities, and now terrorist act is defined as a separate offense. So that is the first provision. The second provision is the offense of sedition, a very controversial clause in our IPC. The offense of sedition has been omitted. Okay, basically the offense of sedition has been omitted. All right, which penalized any type of actions or any type of words against the government. Okay, now what they have done is, criticizing the government is part of the democracy, so they have changed this criticism to the government to the criticism to the nation. So the new Bharatiya Nyaya Sanhita Bill, this will replace Rajadroha. Okay, it will replace Rajadroha with Deshdroha. That is, now there will be punishment if any acts are done that will endanger. Okay, if any acts are done that will endanger the unity and integrity of India. Okay, the unity and integrity of India. It is not about the government. It is not about the government. It is about the nation. So the Sedition Act mainly focused on the government. Any criticism on the government was to be punished. But now they have removed this sedition clause, and they have added a clause wherein punishment will be given if there is anything that you endanger regarding the unity and integrity of India, that is, nation takes the precedence. So they say that citizens definitely will have the right to talk against the government, and this is protected. But any acts against the nation, will not be prohibited. That is what is the takeaway from the second provision. Again, a very progressive move. So both are considered very progressive. The next, the third one, that is again another progressive move according to me, is mob lynching is made a separate offense. Mob lynching is made as a separate offense. That is good. And this mob lynching will also, maximum it will invite death penalty. See, this is very, very important because mob violence takes place very, very frequently in India, and mob violence is where your actions become invisible with the presence of crowd. So when there is crowd, since our actions become invisible, we tend to be more violent, and our violence will result in greater harm to human rights. Hence, having a law that will have death penalty as its maximum punishment, and it is dealing as a separate offense, that brings a type of deterrence for those people within the crowd to take up law in their own hands. So I would suggest that this is again a very, very progressive insertion of this clause within our Bharatiya Nyaya Sanhita Bill. Okay. The fourth is several minor offenses that happens. So these minor offenses, instead of making it a big thing, they have included something called community service. So this community service can be given to them as a punishment in order to give them a scope of reformation, and also to act as penalization of committing such minor offense. Now this is an idea that has been taken from Western democracies, where Western democracies have some type of community service, where if there is any commission of minor offenses, then you are told to make sure that you provide 100 hours of community service or 200 hours of community service. You have to serve by cleaning some places, or you have to serve like in an elderly home. So all these are community services that can happen, which is again a very good and progressive way of trying to not push a person inside prisons, but to make sure you are giving scope for that person to correct oneself and reform one's personality. So again, it is a progressive move according to me. The next is The compulsory, okay, the next is compulsory collection of forensic evidence, okay, in the investigation. This will obviously strengthen prosecution. Now, why will this be helpful? Is it will help improve conviction rate. In our criminal justice system, if you take any crimes, our conviction rate are abysmally low. Okay, you take our POXO Act, conviction rates are low. You take rapes, the conviction rates are low. You take murder, the conviction rates are low. You take any type of criminal acts, our conviction rates are very low. So again, this is a progressive move that will focus on forensics, that will improve our prosecution. Okay, the next is audio and video recording. Audio and video recording has been made of the sexual victim. The victim that has suffered sexual violence. Okay, audio video recording of the victim who has suffered from sexual violence has been made mandatory. Again, as you can see, this is more humane. Rather than calling that particular victim to the court, if you have an audio and video recording, I think that should suffice in taking forward the trial of that particular case. Okay, that is the next one. The next is there are provisions that fix the accountability of the police. There are provisions that fix the accountability of the police. So this is another progressive move. Okay, and the provisions that are present ensure victim-centric justice. Instead of focusing more on, or instead of putting more burden on the victims, okay, the prosecution or the entire penal code will now be more towards the victim. It will help victim to get justice rather than it will put burden on the victim to provide evidence. Okay, the next is it gives a provision of zero FIR registration. Okay, again a progressive move. Zero FIR registration will allow you to file an FIR in any police station. You need not always go to that jurisdictional police station to file an FIR. You can file the FIR in any police station. That FIR that is filed anywhere will be passed on to the jurisdictional police station within 24 hours. Okay, that is again a progressive move. You file the FIR in any police station, but from that police station, the FIR will be transferred to the jurisdictional police station within 24 hours. That shows that there is time bound, justice system that can be, foreseen. Okay. The 10th step of this particular, this thing is the Bharatiya Nyaya Sanhita is the courts cannot allow state to withdraw cases. The court cannot allow state to withdraw cases without hearing the victims. See, again, this is a victim-centric move. You are giving more priority on the victim. See, when you make zero FIRs, when you allow the victims to be heard before withdrawing the trial, and when you are making audio-video recording compulsory in the victims, if that victim is involved in a sexual violence, all this points out that we are moving towards victim-centric justice, which is actually again good. Okay, and the next is serving of the copies. See, again, serving of the copies of police report. The serving of the copies of the police report to the victim has been made compulsory. Compulsorily, the victim has to be given the copies of the police report. See, again, it is becoming more victim-centric. Okay, and this these are some of the important provisions. Okay, and just last one, other few cases are, they have dealt with hit and run cases. Now, hit and run cases are created as a separate offence, and here the maximum punishment is given up to 10 years. That is one. Okay, the second is they have made snatching. Snatching also is created as a separate offence. Also, if the offence creates any type of grievance hurt, if the offence is very highly grievance, or if it creates a grievance hurt, then again it is created as a separate offence and the maximum punishment is given as 10 years. So, to just summarize how it is more progressive, the Bharatiya Nyaya Sanhita bill, Terrorist Act is created as a separate offence. The offence of sedition has been omitted. That is from Rajadroha, that is, you can criticize the government, you always have the right to criticize the government, so this has been omitted. But what is being punished is you cannot criticize the nation, you cannot affect the unity and integrity of India. That is being punished. So the offence of sedition is again omitted. The next is mob lynching is created as a separate offence. Minor offences will be treated as a minor offence and given community service instead of imprisonment as a punishment. Forensic evidence has been given priority. Audio video recording, fixing the accountability of the police, zero FIR, then victims to be heard before the court withdraws any cases from the state, the copies of the police report given to the victims. All this points to victim-centric justice. Okay, all this points to victim-centric justice. The next is hit and run cases as well as snatching and offences that create grievance hurt are created as separate offences. So these are some of the important, part of the Bharatiya Nyaya Sanhita bill. And as I told you, these are progressive in nature and they are in tune with the trends of what is happening within India, especially within our criminal ecosystem. Okay, now let us look at a few of the aspects of our Bharatiya Nagarik Suraksha Sanhita bill. Okay, so if we have to just look at the if we have to look at the Bharatiya Nagarik Suraksha Sanhita bill. Okay, in this bill they have created something called time bound justice. Remember that this is replacing what we call as Code of Criminal Procedure. It is replacing the Code of Criminal Procedure, and Code of Criminal Procedure did not have a time bound justice, but this Bharatiya Nagarik Sanhita Suraksha Sanhita bill is creating a time bound justice. So the first and the most important thing is BNSS. Okay, this I'll keep terming this as BNSS. So this makes FIR to be registered. FIR is to be registered in 3 days. Okay, FIR is to be registered in 3 days after the making of the complaint. It should not take more than 3 days. Once if a complaint is made, within 3 days, FIR has to be registered. Okay, now if let us say that if there is any offences for which complaint has been made, which these offences will invite 3 to 7 years of punishment, then FIR has to be filed within 14 days. Okay, so FIR for lesser offences should be filed within 3 days. FIR for much higher offences should be filed within 14 days. That is the first aspect. The next is investigation. Once the investigation starts, investigation should be completed within 90 days. Okay, investigation should be completed within 90 days after the first charge sheet. Once the first charge sheet is done, within that 90 days, the investigation has to be complete. The next is the magistrate, the district magistrate should take cognizance of the charge sheet within 14 days. Once the charge sheet is filed, within 14 days, the district magistrate should take the cognizance of this charge sheet. Okay, the next is time limit. They have introduced a time limit for medicinal reports or medical reports that need to be submitted. For example, with regards to sexual violence cases, medical reports has to be submitted within the time limit. Okay, and also one more provision that they have brought within this bill is something called trial in absentia. Something called trial in absentia. What it means is, if an accused will not appear in the court within 90 days, if the accused will not appear in the court within 90 days, then the trial can be carried with the absence of that person. This happens mainly when people leave the country and go and they are always absent. If that is the case, they can wait for 90 days, and if they do not come, then the trial can happen in their absence. That is another procedure that is brought. Okay. Now one more time bound procedure is judgment has to be delivered within 45 days after the conclusion of hearing. Okay, judgment has to be delivered within 45 days after the conclusion of hearing. That is another provision. Okay, the next is EFIR. They have introduced something called EFIR concept. EFIR concept is basically a registration of FIR through electronic means. This again is a very progressive procedure. So these are some of the important changes in the procedure, criminal procedure. So to just summarize, the Bharatiya Nagarik Suraksha Sanhita bill, which is replacing the Code of Criminal Procedure, first it brings up something called time bound justice. Time bound justice is FIR within lesser offences must be filed within 3 days. Higher offences must be filed within 14 days. Investigation should be finished within 90 days after the first charge sheet. The charge sheet filed must be taken cognizance by the district magistrate within 14 days. Time limit is prescribed for medicinal reports or medical reports that needs to be submitted during investigation. There is trial in absentia, where if an accused is absent for more than 90 days, then the trial can continue without that person. The judgment has to be given in 45 days after the hearing is concluded, and the concept of e-FIR is introduced, which again is progressive because we can file FIR through electronic means. So these are some of the important provisions that are introduced within the Bharatiya Nagarik Suraksha Sanhita bill. So this new avatar is a very, very progressive step within our criminal justice ecosystem, and I hope with this our prisons, our police and our judiciary will be active in creating a very robust criminal justice system. It will be active in creating a very robust criminal justice system. So this is the first issue of the day. I hope you understood the issue thoroughly. Alright, again, you don't have to wait for them to ask about this bill, because it is very, very less likely that they will ask. The point is, you use these provisions of the bill in your answers. You use these provisions in your case studies. If they're asking you any type of steps to be taken, you use these provisions in your GS2 to improve governance, to improve sympathy, empathy, to improve human, to protect human rights, to protect the unity and sovereignty of India. So the scope to use these provisions are very, very vast, which you can use in every paper, every general studies paper. All right. So make sure that you have made a note of these provisions, that in turn can help you to use it in your answers properly. Okay, with that, let us go to the next issue of the day. The next issue of the day talks about Indian federalism. Okay, it talks about a missed chance to strengthen Indian federalism. The constitution is not always clear on the balance of power between the center and the states. The Supreme Court's J&K ruling stopped short of clarifying it. Okay, so federalism is a very, very important topic in your UPSC preparation. We know that federalism is something that is important for both prelims and mains. So you should have a very good amount of notes that are made within, for federalism. Okay, so if you take federalism in India, if you take federalism, we have what we call as Granville-Austin. Okay, Granville-Austin will define Indian federalism as cooperative federalism. He defines Indian federalism as cooperative federalism. Then we have Ivor Jennings. Okay, Ivor Jennings, he says that India is a federation. Okay, India is a federation, however, with the strong centralizing tendency. Okay, so India is a federal nation, or India is a federation with strong centralizing tendency. Okay, this is what is told by Ivor Jennings. Okay, however, Ambedkar describes that, first let me just tell you what Article 1 of the Constitution tells. So Article 1 of Indian Constitution tells that India is a union of states. It describes India, that is Bharat, is the union of states. Now here they preferred union and not federation. And when Ambedkar was asked about this, the phrase union of states is preferred rather than federation of states because of two reasons. Okay, the first reason that Ambedkar says is Indian federation is not an agreement. That is, Indian federation is not a result of any agreement like American federation. That is the first reason. The second reason the Ambedkar says that the states in India have no right to secede. They have no right to secede. Okay, so hence India cannot be called as federation of states. India is called as union of states. Now this is the overall background of Indian type of federalism. Indian type of federalism is considered as sui generis. Sui generis is, it is a unique type of federalism wherein you have both dual polity. You have dual polity, that is, you have the existence of center, you also have existence of state. However, though there is center and state that are existing, alright, that does not mean that the state has complete independence or absolute autonomy. The center is given a bit of more inclination, or the center is a little powerful compared to the states. Okay, so as Ivor Jennings has correctly put it, India though looks like a federation, however there is a strong centralizing tendency when it comes to the Indian federalism. And also, if you take the Article 1 of the of our Indian Constitution, it also points out that India cannot be considered as pure federal state. Okay, so this is something that you should know. All right, now there are two important cases that talks about federalism in India. The two important cases are, one is S.R Bommai case versus Union of India. S.R Bommai case on Union of India. Now in this S.R Bommai case of Union of India, it was in 1994, and here they in this case the Supreme Court decided that federalism is to be included in the basic structure of Indian Constitution. Okay, so because federalism is included in the basic structure of Indian Constitution, the central government cannot outrightly change the relationship between the center and state. Okay, the center and state relations are sacrosanct to the Indian Constitution, and central cannot change the relationship dictated within the Indian Constitution alone with its own authority. So that is what is federalism becoming part of the basic structure. Okay, and also in the same S.R Bommai case, the Supreme Court has told that though greater power has been given to the central government, okay, though greater power is given to the center, that does not mean that state are mere appendages. Okay, though center is given the greater power, that does not mean that state are mere appendages. It means that states within their sphere, have their own existence. Okay, the states within their sphere are supreme. The states within their sphere are supreme, and they have their own independent existence, and the center cannot intervene. The center cannot intervene within this particular sphere of influence. Okay, so with this particular judgment, federalism was given a proper structure by the Supreme Court. It gave a type of legitimacy to the to the survival of the states. It gave a type of legitimacy for the sphere of the state. Okay, by telling that states are not mere appendages of the center, and within the sphere states are supreme, independent, and center cannot intervene, it has upheld the powers of the state that is enshrined within the Indian Constitution. So in that way, S.R Bommai case plays a very, very critical role in upholding the principles of federalism. Now the second important case that you have to talk with respect to federalism is the Delhi government. Okay, the Delhi government versus Union of India 2023. Okay, Delhi Government and Union of India Act 2023. Here our current Chief Justice of India, who has also told that state governments are not just bound to be different. Okay, the current Chief Justice of India has given the statement that state governments are not bound to be different. They are not bound to be different, but they are intended to be different. See, what it means is, it is just trying to reaffirm whatever was told in the Bommai versus Union of India 1994 case. What the Chief Justice of India is trying to tell is, states are intended to be different. States have their own existence. They are, they need not act as different, or they need not be bound to be different, but they are intended to be different by the Constitution. This is what the Chief Justice of India has told. The Chief Justice, by telling this, okay, by this judgment, the Chief Justice of India has said that the idea of collaborative justice, and the idea of collaborative federalism are the ways to go forward for the center-state relationship. If the center-state relationship has to thrive, then collaborative justice and collaborative federalism is the way forward. This is another judgment that points out or gives a proper structure to the Indian federalism. So I am going to tell you the two cases again. One is S.R Bommai case, and another is Delhi Government versus Union of India case 2023. These two cases laid the foundations for what are the principles of Indian federalism. These are the two cases that has given shape to the powers and spheres of influence of the state, and as highlighted that states are not mere appendages, or they are not just bound to be different, but they are intended to be different because within their sphere they are supreme. So in that way, these two cases have really highlighted and given the powers to the states. Okay. However, now if you go back to this particular thing, this article, the author tells that we have a missed chance. Why is the author telling that we have missed a chance? Is because in the Jammu and Kashmir case, okay, about Article 370, okay, in Jammu and Kashmir case about the Article 370, now what the government had done, the union government had revoked Article 370. We have discussed this in plenty in the previous video. It has revoked to 370, and two, the state of Jammu and Kashmir, okay, the state of Jammu and Kashmir was converted to union territory. Okay, the state of Jammu and Kashmir was converted to union territory. Okay, now this is what the government had done. All right, now if we come back to the Supreme Court case of Jammu and Kashmir, the Supreme Court has upheld the revocation of Article 370. It has upheld the revocation of Article 370, and it has given a time bound holding of elections. It has given a time bound holding of elections within the Jammu and Kashmir. And what the author is not happy about is, the author is telling that the Supreme Court did not address a time bound judgment. It did not address the time bound judgment of returning the statehood of Jammu Kashmir. It says that the Supreme Court did not address the returning of statehood of Jammu Kashmir. Okay. Now what the author is arguing is, if you take Article 3 of Indian Constitution, Article 3 of Indian Constitution gives the power for the government, union government, gives the power for the central government to form a new state. It gives the power to form a new state. That is one. The second, it gives the power for the central government to change the boundaries. Okay. One, it gives the power to form the new state. Two is it gives the powers to change the boundaries, and third, it gives the powers to name the states. These are the three important provisions that the Article 3 provides the central government, but nowhere in the article it allows the central government to change the state to a union territory. Okay, now this is something that is not provided within the article. So what the author tells is, Supreme Court should have addressed this and told that because there is no article that talks about changing the statehood to union territory, the author says that Supreme Court has missed a chance to provide a time within which the union government has to return the statehood of J&K. Now the union government has told that they are going to return the statehood as soon as possible. This is something that they have told. However, the Supreme Court has kept quiet on this. Instead of keeping quiet, the author feels that the Supreme Court should have given a time bound within which they had to return the statehood of J&K. So this is one part where the author feels that Indian federalism could have been much more strengthened by allowing a time bound return of the statehood, which was not addressed by the Supreme Court. So that is what the author is talking about in this article, a missed chance to strengthen Indian federalism. Okay, so I hope you have understood the issue from both prelims angle as well as mains angle. The background story that I gave is mainly for prelims, and the issue that has happened is mainly for the mains perspective. Okay, so this is about this issue. The last issue of the day is, unfortunately, there is still manual scavenging that happens in India, and this manual scavenging is against the fundamental rights. Okay, it is against the fundamental rights of Article 17 and Article 21, and it is an inhumane practice that has resulted in the loss of lives. First of all, it is inhumane practice because it is against the dignity of an individual. Okay, on top of that, it has resulted in loss of lives due to asphyxiation, that is due to lack of oxygen. All right, and this manual scavenging is prohibited. This manual scavenging is prohibited. The reason I say this manual scavenging is prohibited is, we have passed a bill called Prohibition of Employment as Manual Scavengers. Prohibition of Employment as Manual Scavengers Act of 2013. Okay, Prohibition of Employment. Okay, Prohibition of Employment as Manual Scavengers Act of 2013. Okay, so in this, any person who employs people for manual scavenging, they will be given a punishment of up to 2 years and a fine of up to 1 lakh. The second is you have to rehabilitate. We have to rehabilitate those people who were performing these functions of manual scavenging. Okay, and also it abolishes all types of manual scavenging or septic tanks cleaning. Okay, manual septic tank cleaning. Okay, it abolishes all types of manual septic tanks cleaning, and it provides a punishment of 2 years and up to 1 lakh fine for those people who are able to, who are employing manual scavengers. And it also provides a provision to rehabilitate the people who have been employed as manual scavengers. Okay, so this is what is some of the prohibitions of prohibition of employment as manual scavengers, Act 2013. However, the abysmal, the unfortunate, statistics that is given by the Ministry of Social Justice. The Ministry of Social Justice has given a survey report, and in this survey report, from the year 2013 to 2018, there were 58,098 manual scavengers employed. Look at this unfortunate event. Okay, there were 58,098 manual scavengers were identified from 2013 to 2018. This is complete violation of fundamental rights, and it is a complete violation of human rights. However, it is still being practiced, though there was a Supreme Court judgment in 2014 which has strictly told, this is a landmark judgment that has told that we have to abolish manual scavenging. We have to abolish manual scavenging. Okay, so this manual scavenging is still practiced, and the reason why we are discussing this entire thing is because of a recent case that came up in Karnataka. The recent case that came up in Karnataka. In Karnataka, there was a video that went viral where school students were made to clean. Okay, school students were made to clean septic tanks. Okay, in a school called Morarji Desai School, and the students were from the standard of 7th to 9th standard. Okay, they were from 7th to 9th standard in the Morarji Desai School. School students were made to clean septic tanks. Now they were made to clean septic tanks under the label of social service. They were made to clean septic tanks under the label of social service. Look at this case study. Analyze this case study. Just by labeling it with some name, creating an action that is inhuman, violating the fundamental rights, can you undo such type of violation? Don't you think this shows utter lawlessness? Don't you think it is completely careless and incumbent on the school management, as well as on the teachers, as well as on those people who are participants of this activity, to make these students take part in such type of heinous crime which is being labeled as social service? Now this is a case study which you have to analyze. You have to know how the law is constantly overlooked, how there is no respect to the law of the land, there is no respect to the judgment given by the Supreme Court, as well as there is no respect to human rights. Okay, now this is a gross violation of human rights, and there has to be some type of, obviously the school management and principal have been suspended, but just by suspending those principal, we will not be able to bring the behavioral change. One, we have to set an example so that such manual scavenging activities should not be done. Next, manual scavenging should be abolished, and we have to, under any circumstances, create a deterrence effect so that people will not consider themselves above the rule of law. And finally, we have to teach our kids, our children, our students about the ill effects of manual scavenging. Not only about the health affecting, or not only because it will result in the loss of life, but more importantly, it is because it is inhuman, because it hurts the dignity of the individual. Okay, so in this way we have to inculcate from values perspective, we have to bring behavioral change, we have to change the attitude of the people. Only then we will be able to abolish this inhuman act of manual scavenging. So I hope you learned about the prohibition of employment of manual scavengers Act 2013. You saw the Supreme Court judgment of 2014 and also the survey of Ministry of Social Justice that says till today we have 58,098 manual scavengers, which is unfortunate statistics that we have. Okay, now obviously the government has done or taken up several type of initiatives. One, obviously it has come up with something called Swachhata Udyami Yojana. Okay, it has come up with something called Swachhata Udyami Yojana. This is basically from National Safai Karmacharis Finance and Development Corporation. This basically allows these ex-manual scavengers to get some type of rehabilitation and loan so that they can do some other work. That is the first action taken by the government. The second is you have something called a central sector scheme. A central sector scheme that is known as self-employment scheme for rehabilitation of manual scavenger. Okay, we have something called self-employment scheme for rehabilitation of manual scavengers. Here any manual scavengers will get a subsidy of rupees 5 lakhs to start. It is a capital subsidy. So if you have to start a business, you will get a capital subsidy of 5 lakhs for procurement of any type of instruments or vehicles or any type of self-employment that you want to start. So these are two initiatives that are started by the government, which again is good, but the reason why we are not able to eliminate this manual scavengers is, one, we are not able to change the attitude of the employers, and we are not able to improve the conditions of the employees. So until we improve the conditions of the employees and we change the attitude of the employers, we will not be able to abolish manual scavengers. Until then, the prohibition of employment as manual scavengers Act 2013 will remain as irrelevant as we see today. Okay, so only bringing the behavioral change on the part of the employers and improving the conditions of the employees, we will be able to abolish this inhuman act of manual scavenging. Okay, so I hope the initiatives were helpful, and I hope you are understanding the perspectives as well as the issues, the spirit of those issues, so that if you understand the spirit of the issues, the same spirit will be reflected in your answers. So I hope it is helpful, and thank you for tuning in. Please make sure that you like, share and subscribe, guys. Thank you for all the love and support. I'll see you tomorrow, guys. Bye.